dignitaries and friends on the dais and off the dais. When the executive committee tasked me with the important responsibility of finding a speaker for this year's memorial lecture, the first person I thought of was Dr. Aditya Sondhi. We were contemporaries at the National Law School, where we both studied law. Aditya graduated in 1998. I graduated a few years earlier. And I've had the opportunity of hearing him speak. And since then, I really wanted an opportunity to invite him to ECC. He's now based in Delhi, and he comes to Bangalore only twice a month. So I was not sure if he would accept our invitation. I just sent him a WhatsApp message informally asking if he would come. And within an hour, he responded, honored to be asked. And we are really honored and happy that he has made the time for us to be here with us today. Dr. Aditya Sondhi is a senior advocate who practices before the Supreme Court of India. He has also served as Additional Advocate General for the state of Karnataka from April 2016 to April 2018. And he has appeared in several matters of public importance. He regularly also appears before various high courts in the country. Dr. Sondhi is also a known academic, and I don't know many lawyers who can do both seamlessly. He has taught constitutional law, arbitration, and professional ethics at the National Law School of India University. He has also taught a specially curated credit course on courts and national security. He has contributed to the Oxford Handbook on the Indian Constitution and was invited to appear before the Parliamentary Standing Committee on Home Affairs, which was instituted in connection with criminal law reforms in 2023. Dr. Sondhi has lectured widely in India, as also in the UK at Oxford University, London School of Economics, SOAS, King's College London, and Bristol University. He holds a PhD from Mysore University and has published 3 books of nonfiction with Penguin India, including his most recent Poles Apart, which examines the relationship between military and democracy in India and Pakistan. Those of you who are from Bangalore and associated with Bishop Cotton's have probably read some of Aditya Sondhi's books on the institution. He was also the head boy of Bishop Cotton's a lifetime ago. Dr. Sondhi appears in matters of criminal and constitutional law with a special interest in human rights advocacy. He has appeared pro bono in several death penalty cases before the Supreme Court of India, including Munna Pandey vs. State of Bihar, which lays down cardinal principles for a fair trial. He has instituted the Beena Sondhi Scholarship for an LLM in Human Rights, Conflict and Justice at SOAS University of London in memory of his late mother. He hosts Podcast, PODCASTE, which is a podcast for conversations around caste. He is a giant in the field of legal practice, and he upholds the spirit of the Constitution of India in all aspects of his work. I cannot think of a better person to deliver this year's lecture. Once again, Aditya, welcome to the ECC, and thank you personally from my own behalf as well for accepting this invitation.
Thank you. Thank you. Thank you, Saraswati.
Thank you, ma'am. With great joy and anticipation, we welcome our speaker, Dr. Aditya. Over to you, sir.
Thank you, Sarasu, for that wonderfully personal introduction and for this invitation. What Sarasu didn't mention is that when we were 3 years junior to her at law school, she would take special classes in the most difficult courses we had, especially jurisprudence, I think. So many of us have actually been able to clear the law school thanks to her. So it's literally a full circle for me today to be here today to speak at this 32nd Reverend M.A. Thomas Memorial Lecture. The Most Reverend Dr. Theodosius Marthoma Metropolitan, Chairperson ECC, the Very Reverend Dr. Shyam P. Thomas, Director ECC, Mr. M.O. Verghese, Sarasu, of course, Dr. Anila George, members and friends of Dr. M.A. Thomas, Mr. Dasgupta, ladies and gentlemen. Not only was I honored to receive this invitation, I was quite bemused. Looking at the list of the previous 31 speakers, you see the names of Justice Krishna Iyer, Swami Agnivesh, Vandana Shiva, my good friend Reverend Kiran Sebastian. The mind boggles. I feel like a bit of an imposter here. I think it is Sarasu's generosity that I'm here. And worst of all, sir, you commended Sarasu for inviting a good speaker. I wish you had saved that compliment till after the speech. It is also, I think, to the credit of ECC that you've been able to have 32 uninterrupted memorial lectures. It's no mean task. I've been part of a few memorial trusts, and I know the challenges, the difficulties that go with organizing events like this. And it's truly, I think, a matter of pride for the city of Bangalore that these lecture series are going strong. And from the portrait that has now been unveiled, you can see in the eyes of Dr. Thomas the clarity and the energy that only a man of God and a man of action could have. And therefore, it's a deep honor for me to be speaking in his memory today on a topic that I believe is something that he would have cherished. And indeed, his life and work was dedicated to the pursuit and advocacy of human rights. As the Most Reverend Doctor said, the topic is chosen carefully. It's pithy, but I believe it's loaded. Human rights advocacy does not begin and end with advocacy in court, though much of what I say will cover that part of advocacy because that's the advocacy I know best. And of course, the element of New India, which, let's face facts, is an India that throws up challenges and even crises for those in the space of protection, advocacy, and enforcement of human rights. I joined the bar in 1998. At that point, the Karnataka bar. At that point, the bar was a fairly friendly space, I would say. Maybe I was naive to some extent. But generally, it was a welcoming, amiable space, not politically divided, not quite as polarized as most systems are in the country today. And importantly, a bar that had space for all voices. Some of us actually began as commercial lawyers. And my journey and my engagement with public law and human rights is something that has really mutated over the years. But this was a bar where your friends could be tax lawyers, they could be criminal lawyers, they could be pro bono lawyers doing human rights advocacy, some very fine trade union lawyers who espoused the causes only of the workmen on principle. And each of them had their own space and their own niche. And there was really no value judgment made either way. I find that with human rights practice in India now in 2025, and I would say over the past few years, that has markedly changed. The bar is no longer, I'm disappointed to say, a space that liberally accepts and encourages those in this pocket of human rights advocacy. I personally admire and look up to those who are in that space. But I have seen for myself, I've experienced to some extent myself, and I know from friends who are in full time pro bono lawyering, the sorts of disadvantages and persecution they face. So when we speak of human rights advocacy, this becomes almost an instance of double jeopardy. You're, as it is, up against the state, you're often up against powerful and multiple lawyers, especially if the list that you're fighting involves, say, corporations. You're representing a client or a cause that is often invisible, voiceless, non paying, and added to that is the fact that the counsel representing these causes in these cases, rather than being celebrated as the heroes of the profession, in my opinion, are the ones who face alienation and at times even persecution. We know of lawyers, Sudha Bharadwaj's case and several others, where lawyers are not just persecuted, they are prosecuted. But short of that, also, it's not smooth sailing. I have seen and I have sensed this certain arm's length that the majority of the bar chooses to keep from those in the space of pure human rights advocacy. A certain othering of those within the profession. And this, to me, I think, is one of the crises of our system, in that rather than promote and propagate this space for young lawyers, for young activists, for NGOs, for individuals and people with a fire in the belly, we're actually creating a sort of system where human rights advocacy, amongst many sections of the mainstream bar, is seen as something that is a sort of taboo. Comes with this, of course, is the trolling and threats that many lawyers face in the course of their advocacy. Sarasu mentioned in my introduction some of the death penalty work that I do. And the moment one picks up a case for an accused on death row, you're surprised to find that at least social media of New India is dead against you, because there's value judgment being passed. How dare you represent an accused? And trust me, these are heinous offenses. There's no moral high ground here that any of us take. It's really a commitment to the rule of law. I know that Mr. Verghese said human rights go beyond rule of law, but most certainly they locate themselves within the idea of rule of law. So when you act for a death row accused, convicted of an offense, say under POCSO, for the abuse and murder of a young girl child, it's no easy assignment as a professional. You have your own moral qualms that come into play, spiritual qualms if you're that way inclined, but you also have a certain professional ethical calling that requires you to espouse each case to the best of its outcome. But the moment you pick up one of these briefs, you become anti-national, you become urban Naxal, you become someone who's out to defend rapists and terrorists and so on. And that is a hugely reductionist discourse that New India has arrived at today, because we're not creating room for this advocacy. And as I said, one look at a file tells you exactly where you stand, even morally. The file will tell me where I stand legally. It will also tell me where I stand morally. There are cases which I've argued on death sentence, where one quite recently actually, of a gruesome honor killing by a father of his 8 months pregnant daughter. The file and the evidence showed me that the man was guilty. But all the same, India especially through the Supreme Court's jurisprudence, is moving towards a de facto abolitionist jurisprudence when it comes to death. And we argued that case. The court didn't acquit him, but certainly commuted his death to life. That is the charity or the generosity of the law. But contrast that to a case that Sarasu mentioned in my introduction, which is the Munna Pandey case, which was a case equally gruesome on paper, because this individual was accused of the sexual abuse and murder of, I think, a 9-year-old girl in his village. Gruesome as it is. But shockingly, we found, and the court found, after 2 rounds of concurrent death penalty at the Sessions Court and the High Court, that this person had been framed. The accused, well, by surmise, we found could have been a juvenile in the village. There was obviously an uproar in the village. The juvenile spent about a year or so because of the protection of the Juvenile Justice Act, and there was a need to fix someone for it. He was fixed, spent, I don't know if I remember, 10 or 11 years in prison, never got bail, had the sword of a death sentence hanging on his head till the matter was heard in the Supreme Court, had the stigma of this sentence. His family was not just alienated, but driven out of the village. God knows what other mental health issues this had on him and the family, only ultimately to be acquitted as a result of the order of the Supreme Court, finding that not only fair trial had been vitiated, that there were serious flaws in the evidence. The matter was remanded to the High Court, and within weeks of the remand, he was acquitted. So if this is the shockingly extreme lengths to which law, Indian law, and this is true of many jurisdictions, it's true of the US, which is the most trigger happy to take people to their death, often based on race and class. If this is the extreme divergence in the law, New India or not, the room for human rights advocacy is paramount. But unfortunately, as I said, the blowback on those within the space of human rights advocacy is huge. And therefore, I commend and admire. I'm a part-time human rights lawyer, if you will. But I commend and I admire those who have literally dedicated their lives and practice to this form of advocacy. And this advocacy is not mere professional discharge. It came up in my conversations with Sarasu and my reading on the life of Reverend M.A. Thomas, that he took the plunge between being at the center and setting up Vigil India and being an activist. It's a leap of faith. It's a call that not everyone can make. I have not. I'm not an activist. But there are those who realize that this advocacy, that this battle needs more than this little square in which we function. It needs political, social, grassroots engagement. And that then takes you into a completely different realm. You know, Arundhati Roy's latest book, Mother Mary Comes to Me, a most gorgeous piece of writing. There's a part where she says she's very uncomfortable being described as a writer activist. She says it's unnecessary. To use her comparison, she says it's like saying a sofa bed. But she's right. I mean, in her opinion, all writers write about the geopolitics of their time and the space in which they live. She's right to a large extent. And therefore, in her opinion, every writer by default, in a sense, is an activist. I don't know. That can be questioned also. There are many whose writing is so insipid and removed from the realpolitik of our time that one can scarcely call them activists. But with human rights advocacy and folks in the profession, I believe there is this conscious calling to be made of switching over to the activist side. And who better to remember in this breath than the great Kanabiran himself, K. Kanabiran, who made this call very early in his life and said that my life must go beyond the four corners of court. And his his advocacy and his body of work therefore transcended just the cases that he fought. And I want to quote to you, because it's worth quoting, something he said in his notes in 2007, extracted in Kalpana Kanabiran's very fine biography of her father called Speaking the Constitution. And he says, I quote, "This unfinished Sisyphean struggle has not made me tire of it, but I have been spared of the futile struggle with which Sisyphus was condemned. Mine has been the struggle for a better world, and the struggle is its own reward." The struggle is its own reward. And I therefore want to locate what I'm saying today in this backdrop, that those in the realm of human rights advocacy in India today are no doubt like Sisyphus, struggling. But unlike Sisyphus, as you know, in mythology, he was condemned to carry the rock up to the top only for the rock to roll back. And this recursive curse stayed with him. Those in this struggle are struggling for a better India, are struggling for a reward which is in the process itself. And that reward is not, and that reward and that ideology or that imagination is not confined merely to the process of court. It is in fact a socialistic ideal. We have today challenges in the Supreme Court as to whether secularism and socialism can be regarded as part of the basic structure or not. It surprises me, as if to say we don't have other issues to debate. We want to not reinvent but uninvent the constitutional wheel by questioning what our ethos is. I want to read to you, friends, Article 38, one simple article in the Directive Principles of State Policy in our Constitution. It says, "The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of national life." If this is not socialism, what is? Whether the preamble says it or it doesn't, socialism, in my understanding, the moment social justice is meant to inform all institutions of national life, that's socialism for you. But the debate is often academic. For me, the question now is not simply whether secularism and socialism are part of the basic structure of the Constitution. The dilemma is, are socialism and secularism part of the basic structure of Indian society? Constitutional theory and judgments on constitutional law live and operate in their own space, and may I say in their own limited space. I don't know how much of this permeates to the individuals, the citizens, and as I said, the invisible Indians who are affected by these conversations. They are affected by the ethos that you and I carry as individuals. And have we as a society in New India moved closer to a socialist secular ideal or not? In fact, on socialism, I have my serious reservations. I don't think India, other than few phases in its early history, has ever really had a serious economic policy commitment to socialism. I think many of us and many others have consoled themselves that we have a socialist ideal. Corporate capitalism has been a way of life. And there are, of course, the odd trickles here and there. But at least till some years ago, I did believe that secularism was inherent in our fabric as individuals. We studied Christian schools. We partook in events like this where multiple faiths and communities come together to ideate and to mingle and to have fellowship. We had friends and colleagues and neighbors we grew up with, agnostic of caste and of religion. But again, I realize that is a small, privileged and inaccurate perception of society. And what New India has thrown up in the past decade or so is a serious challenge to this idea of secularism. And this is where the strengths of human rights advocacy once over come to the fore. And I cannot emphasize this point enough, that amongst all the gains that one has seen with the advocacy, and I speak here more about advocacy in court, one of the gains that I can put my finger on is that New India has, like the emergency did for Reverend Thomas and countless others, been a catalyst for new voices to emerge. I'm proud to see that in this small field of counsels in court practicing civil rights is a new Bahujan voice, is a new feminist voice, is a new queer voice, is a new minority voice. These are authentic voices, friends. I don't have that voice. I come from a certain privilege, but these are authentic voices, lived experiences, not just of the clients and the causes that are espoused, but lived experiences of the professionals and the lawyers that are voicing and articulating those causes in court. And what greater good news, if you will, can there be for this sphere of human rights advocacy in New India? And one can see that difference. You know, I'm reminded of something Bezwada Wilson had once said when he was at a program discussing manual scavengers, that horrible practice that India still follows. And amongst some of the pro bono work I do is representing the families of those who have died in manholes in our own cities, outside our houses and offices. A shame in modern India. Families fighting for compensation, paltry compensation often, for people who have been lost to this inhuman practice. And an inhuman practice passed off as a profession, but betraying deep-rooted caste prejudice. But keeping that aside, at this seminar on manual scavenging, Bezwada Wilson says, on stage was a lady who had the task of carrying human soil, excreta, on her head to clean dry latrines, something shockingly we still seem to practice. And it was Justice Krishna here, one of your former speakers here, on his first order in the Ratlam municipality case, which was the torchbearer for not just human rights jurisprudence, but for public interest litigation in India that dealt with this issue. He saw the need to step in as a jurist 50 years ago, but sadly never could do away with it. And this lady who had this task of carrying human waste on her head, when on stage was asked by a foreign guest in the audience that, how do you feel doing this job? Somebody must have translated it for her. And Wilson says that this lady stood on stage blank for maybe 3 or 4 minutes and said nothing because she could not get a word out. That is how viscerally destructive that task was to her and her identity and her personality. Imagine how thoughtless that question was. That's a question you ask Virat Kohli, how did you feel when you scored your 32nd 100? But the point I'm making here, friends, through this analogy is that there is a certain voice that new human rights advocates are bringing to the fore. They're bringing it to court, they're bringing it to media, they're bringing it to conversations like this. I don't know how many people are listening. Some benches listen, some may not listen. That is a different question. But be rest assured that India, New India, is finding that voice. And that voice is important because, as I said, it's authentic. Any other voice can only be authentic if it finds empathy for people like us who have been blessed enough to have grown up in privilege. the only way to attempt to find that voice is through empathy. And empathy in itself, I think, is a great virtue if you're in this space. Sarsu mentioned the podcast that I do around caste. And every conversation that I've had with my subject has been a very difficult conversation to have. Because I'm speaking to individuals who come from different oppressed and suppressed backgrounds, who are still carrying the pain and trauma of growing up in an India that has othered them. What Thurgood Marshall, the great human rights jurist and activist in America, said, that I know that this constitution is not written for us, but we still have to make it work. That is the predicament of Bahujan India, that no matter how high sounding or grandstanding the Indian constitutional ideal may be, it's really not written for them or with them in mind. These groups and these communities have to find their space and voice within. And in my podcast, when I spoke to individuals who came from these varied backgrounds, I had to be very conscious that any question I asked them did not sound patronizing, that it did not sound like that question that was asked of that lady at the conference at Manual Scavenging. It's a tough line to walk. And my subjects were justified many times to judge me for it, to say, what do you even know? But this is important because Ambedkar himself had conceded that the draft of the Indian Constitution did not meet his ideal blueprint. He is, of course, credited as being the moving force behind the Constitution, and rightly so. And many of the virtuous provisions in the Constitution have come through his good offices, through his advocacy. His advocacy, as you know, he wore many hats, but his advocacy as a parliamentarian, as a political activist, as an economist, as a lawyer, as a jurist, and most importantly, as a prominent member of the Dalit community. That voice enabled a constitution that met a happy middle. But he still conceded publicly that this constitution was nowhere near eliminating or confronting the serious ills that Indian, and for that matter, Hindu community faced through the elements of inequality and caste. But that said, this is the constitution with which one works and lives, and today one must be thankful for it. Because even this constitution is often under challenge. It's in challenge in many ways. It's under challenge from political parties themselves. It's under challenge by way of political amendment, parliamentary amendment, and it's under challenge from the media. And worst of all, as I said earlier, through the forces of society, through friends, family, and extended colleagues of our own in and around us. The threat here, friends, again, is not just theoretical. You know, I'm reminded of that beautiful verse that Amir Aziz said, and I hope it comes back to me in Hindi. He says, "Tum adalaton mein बैठकर चुटकुले लिखो, हम सड़कों दीवारों पे इंसाफ लिखेंगे." You sit in your courts and write light-hearted anecdotes. We'll write justice on the streets and the walls. What a deeply moving two-liner, if there ever was. But the point here is, for those in the space of human rights advocacy, is that one can't get into elite echo chambers and expect the world to tom-tom you. Our work has its limitations. And we must be aware that the work we do and the advocacy that we propagate speaks for and reaches those who are affected. Otherwise, these political systems, judicial systems, etc., can become restricted spaces. Right? As he says, chutkule, I don't know if he's been hauled up for contempt for saying this or not. He probably said it as a poet, though poets are also not safe these days. But the point is that this disconnect between what happens in centers of power, in New Delhi, in parliament, in legislative houses, in courts, and what grassroots everyday India is actually, a tinderbox in itself. Most Reverend Doctor mentioned the example of Nepal. Nepal, Bangladesh last year have both seen political turmoil driven by student movements mostly and civil society arising out of disgruntlement with their political systems, right? Neither of them are Pakistan. And this actually ties in with my book very neatly. My book, Poles Apart, is about the role of the military and democracy in India and Pakistan. And it's a contrasting study to show how the lopsided influence of an extra constitutional body such as the army in Pakistan has completely sort of vitiated the democratic ideals that it might have had when it was set up. And no constitution could save Pakistan. Pakistan, friends, has had 3 constitutions. So their run rate is better than ours in that sense. But with 3 constitutions that all came too late, the damage was already done because the military had eaten into the vitals of the country. And even today, you have a field marshal who speaks for Pakistan. Their presidents and prime ministers often have to toe the line of the army chief, or they're shown the door, as Imran Khan is now facing. But the point here is that the lesson is more serious than what is made out to be, which is that in many ways, the keel that the ship sails on or balances on is dependent on how the country relates to its weakest, voiceless individuals. And if that relationship is threatened, then God forbid the outcomes are serious. This happened in Nepal practically overnight. A social media ban caused it. In Bangladesh, a president who was running amok with her autocratic behavior changed it. And both countries have slipped into some strange sort of arrangement where you have either caretaker governments or you have interim prime ministers, neither of which are really pure constitutional democratic ideals. An interim, the lady Chief Justice who has taken over in Nepal, I mean, I think it's a welcome choice. Or Professor Mohammad Yunus in Bangladesh, individually welcome choices, but conceptually, they're flawed. You cannot have ad hoc arrangements of people running your country based on who the president thinks should be there or the army chief thinks should be there. That's not how responsible countries function. And India is surrounded by this neighborhood. And we actually ought to be proud of our constitutional commitment over the past 75 years that we have not had the military or XYZ making incursions into constitutional space, but we've committed, at least in our early decades, to having institutional growth and checks and balances. That, of course, quickly changed with 1975, the emergency that bulldozed the very idea of India, and short-lived as it was enough to do damage to that constitutional ideal. But as they say, never waste a crisis. And that crisis actually, in the longer run, I would say did more good to India. It threw up the sorts of political activists, Reverend Thomas and countless others, who actually took India into a new era after the emergency. It saw the political downfall of the Congress party that thought it was invincible. Up until then, nobody could touch the Congress. In fact, the BJP, which is now seemingly invincible, owes itself to the Congress. But for the then Janta government, the BJP would have been a non-starter. It had 2 seats back then. Imagine. In Karnataka, at one point, BJP used to fight for 1 seat. How things have changed. But this is the political churn and the catalyst that a crisis throws up. And people are once over reminded that your commitment to human rights, and human rights not in an esoteric sense. Ultimately, I believe a culture of compassion. I was speaking recently at a seminar on animal rights, Article 21, and new cultures. It seems like every topic I have has something new in it, either a new culture or a new India, but maybe that's how life is. And I spoke about, of course, the importance of us respecting and protecting animal rights, but equally the hypocrisy that one often finds by placing animals as the front for other forms of religious supremacy and moral policing. So what you should eat or not eat, etc., is espoused as a form of kindness to animals, but often becomes a different kind of policing of society. That's not what animal rights are meant for. And Manu Sebastian, T.M. Krishna, in his book Sebastian and Sons, writes about how the makers of the mridangam are required to deal with the skin of the cow. Right? You had a dholak being played earlier. The skin of the mridangam is often made of the hide of the cow. And the professional job of getting that hide ready for the mridangam belongs only to certain castes who are seen as being permitted to deal with the hide of a dead animal. But the domain of Hindustani classical music is with a certain sect, a small sect of upper caste Brahmins in Tamil Nadu, who won't be part of the process of putting the mridangam together, but will proudly play the instrument, to the exclusion of those who have put that instrument together. And this is what Krishna calls out in his book. He says this is the hypocrisy of the art world, right? And therefore there is room for advocacy, not just in courts. This advocacy must transcend every sphere, and not least the sphere of art and music. There's no spirituality in your art form or in your music if you're having Eklavya chop his thumb and say you're not worthy enough to be my pupil. The culture of compassion, as I said, animal rights, the dogs had their day in Delhi, but there are those languishing in jails. Umar Khalid has now become only a symbol of that. There are hundreds for whom we appear on a daily basis with the blowback and the trolling that I mentioned to you to try and fight for bail. The Indian Supreme Court is flooded with bail petitions. You'll be surprised. What you would think is a process, you keep hearing this mantra of bail being the rule and jail being the exception. Well, that's only partly true. You also live in a legal regime where the sheer force of law is such that, as Orwell said, some are equal, but others are more equal. So, for example, in the case of a political retaliatory murder between two communities, say the Hindu and Muslim, in Kerala and Bangalore, as unfortunately we often see in our state and our neighbors, the offenses would be serious, of course, Section 302 of the old IPC for murder. But the application of the law is where things become interesting. That the accused of one community will be charged for 302 simpliciter, kept in jail till the charge sheet is filed, released on bail once the charge sheet is filed, or released in what we call default bail when no charge sheet is filed. Contrasted with the accused from the other community, the minority community, of course, who are arrested in the ratio of 25 or 30:1. So if the perpetrator of the offense are two individuals, you will have 50 or 60 arrests made of Muslim youth for association with organizations which come to be banned prospectively and later. So you could be part of a group or an association which is perfectly valid, carrying out the activities for the betterment of the community, like the ECC does, but one day be declared by a stroke of pen to be an unlawful association, and retrospectively individuals picked up. And here, friends, the charge is not IPC. The charge is UAPA, so terror. Under terror law, the odds of getting bail are exponentially tougher. because of the law itself. Comes with that the new demolition era that we live in. So there's the punishment of imprisonment, there's the stigma, there's the social financial effect on a family because you've picked up, if like in Kashmir, if there's one accused, 5 brothers will be picked up. Property is demolished so that you are then also financially in a state of collapse. Attachment of properties, attachment of bank accounts, so your liquidity is not there. Your liquidity is not there, you may not pay your lawyers. Not everybody does pro bono work. If you're doing cases at a district level, you're not going to file that many human rights lawyers fighting cases pro bono. You may, but it's not necessary that you will. But you don't have the liquidity to pay that lawyer. And as a result, there is a gross miscarriage of justice. And this is the realm in which, in New India, in which human rights advocacy finds itself. And the process is the punishment, as you say, and every other day, one is arguing a case in the Supreme Court where somebody has been in jail for 3 years, 4 years, pending trial, not just pending trial, pending charges, and then released on bail, thankfully, because the Indian Supreme Court has developed new doctrines where Article 21 has been used to get over these stringent terror laws to say your right to life itself is affected if you're kept in jail disproportionately long, and therefore you must be released pending trial. But look at the battle. And how many individuals have the wherewithal to go to the Supreme Court? Is a question to be asked. So when we speak of human rights advocacy, often we get swayed by the role of the Supreme Court and the high courts, but the real deal begins in the trial courts. And this is a conversation for young lawyers. I'm sure Sarasu has it with her students, and all of us must. That trial lawyering is where human rights advocacy first begins. We have for too long, and Justice Oak has repeatedly said this, diminished the role of the trial judiciary. Firstly, by using a disparaging term, just as we do in a caste sense, we have a caste system in the judicial system also. Lower courts. What's lower about them? The moment you say lower, there's a certain disparagement. Of course, they may be lower in terms of hierarchy. You have an appeal to the High Court and the Supreme Court, but they're not lower in the role that they play for justice delivery. When your bail petition or your anticipatory bail petition comes up first before the Sessions Court, there's nothing lower about it. In fact, that is the higher judiciary for the accused or the client. You get your bail order there, you're safe. You don't get your bail order there, by the time you move the High Court or the Supreme Court, you're going to be in custody. The system works on fait accompli. Once the arrest is made, there's no question of anticipatory bail. These are the systems. These are not new. These are systems that policing and prosecution has developed over time in all countries, certainly in ours. So the role of the trial courts, and grossly ignored, not enough time or energy devoted to the appointment of judges with this bent of mind. I have to make this point. When I spoke of the flip side of human rights advocacy in India and the bar that I joined in 98, one would see an interesting diversity on the bench. And we seem to think that diversity only means, gender or religion or caste. That's of course true, but many times that becomes tokenism in itself. I have long argued that diversity must be diversity in terms of life experience and the kind of work one has done. And I think a crisis that human rights advocacy faces today is the absence of sufficient judges on benches who themselves have had a human rights practice. You see, advocacy ultimately as counsel, we present a case to a court to convince a judge or a bench of judges. The relief or the orders still have to come from the court. It's not just theater that you've made your point and discharged your conscience and you go home. At the end of the day, somebody wants an order, a stay on demolition, a permission to hold an event, permission to screen a film, an order of bail to be released, a stay on execution of a death penalty. These are real orders which come from the courts. And I'd like to know How much effort has the Indian system, the collegium system, the law ministry, which is ultimately the power that is in terms of the veto on who can come onto a bench in India, how much effort has been taken to try and find at least a reasonable number of counsels who have practiced civil rights and human rights and bring them onto the bench? I don't see that. There was that to see 20 years ago. May not stark in stark numbers, but it was there. I can count on the fingers on one hand how many judges we might have had in the last 20 years who have belonged to that ideology. This is not to say that it's all bleak. There are many judges we appear before on a daily basis who, as I said, may not have had that practice, may not have had that life experience, but have the empathy. And through empathy have developed the march of the law. And that is the charm of human rights practice. I'll tell you, friends, in New India, with all the challenges, is the fact that the room for the growth and the march of the law is that much greater. There are so many new principles being laid down, not least in the contours of bail and death sentencing. But nonetheless, and especially when we speak of the trial judiciary, we have to reimagine this process. Nobody regards a trial court as a constitutional court. Yes, constitutional powers per se are not vested in those judges. But if grant of bail is not an Article 21 relief, then what is it? It's in spirit a fundamental rights court, is it not? And you have the Human Rights Act, which has provisions for human rights courts, special human rights courts to be set up. I think that time has come. We speak about tribunals all the time, and we have tribunals galore. This is where I would say capitalist India has the march on us. Fantastic, not all, but some fantastic tribunals, dealing with, electricity and competition law and insolvency and tax and very niche areas. It's time for human rights courts and tribunals now, with individuals that man them or woman them, who've had this side of practice to them. Otherwise, human rights advocacy is a one-way street. It's an echo chamber. You most of the time hearing your own voice or the voice of friends around you. That's not enough. As I said, it has to go back to those who are affected by it. I did say, friends, that there's room for advocacy outside of the law itself. And recently I saw the censor board had banned a film called Punjab 95, based on the life of Jaswant Singh Khalra, who was an activist in the Punjab in the 80s during the peak of the terror movement in the Khalistan movement in Punjab. And he was an individual who shockingly uncovered, believe it or not, 25,000 extra legal deaths. 25,000. I know how our conscience is shattered today when we hear of the numbers from Gaza, but this was in a state in India 40 years ago where there were 25,000, according to his research, extra legal killings or disappearances. And friends, my friends from ALF are here, Mridula is here. We work on cases dealing with encounter deaths, which India is infamous for. Again, lot of blowback. Why do you represent some Bihari laborer who has abused and murdered a 9-year-old child? You should be ashamed of yourselves. And on the other hand, the hero in the system is the policeman who shoots that individual dead in cold blood. That is celebrated as gallantry. I do not know what is the gallant act in shooting somebody who's probably handcuffed, shooting them in cold blood. But that's New India. So that is the example to emulate. The bold gallantry of the officer shooting someone in cold blood. And the person picking up the case for the family of that deceased is, of course, a traitor, because you are representing the scum of society. What is often lost, the nuance that is lost, is that presumptions that people make sitting in their living rooms watching Arnab, presumptions that इसी ने किया है is not always the truth. The person, the offender, and the one shot in cold blood can often be two different individuals. Of course, never belonging to an elite strata, right? When we speak of death sentences, etc., show me cases where somebody belonging to, the business community or an upper caste individual has been sentenced. Forget about sentenced. Good luck getting a conviction also. All those horrible instances of actual cold-blooded shootouts in Delhi at bars and so on, have taken the families lifetimes to try and get some convictions or the other. But here was this Mr. Kalra who said 25,000 extrajudicial killings in the state of Punjab. And most paradoxically, he met the same fate. He was allegedly, as most things, these are all alleged, picked up by the Punjab police, disappeared, and one has to presume after 40 years, done to death in some police station or in some village somewhere. So the next thing you know, that 40 years later, Hani Trehan is making a film on his life called Punjab 95. And that film faces the block of the censor board. And that tells you, friends, I mean, this is here actually an instance of the Sikh community being targeted during a time when the Congress was in power. So in many ways, there are political alliances that go beyond what we can see. Censor board said, no, you can't release this film. I believe they had recommended some 120 cuts. And one of the cuts, one was the change of the name, which they agreed to. One of the cuts proposed was, don't say 25,000, say 3,000. To which the director said, are you saying 3,000 is all right? So obviously the director didn't agree, saying it's inaccurate, it's inauthentic for a filmmaker to tone down the very cause for which the protagonist lived and died. And the most peculiar thing in this case is the fact that the case ultimately went to the court, I think the Bombay High Court. The Bombay High Court was on the verge of staying the order or quashing the order of the censor board and permitting the release of the film when the matter was adjourned. And overnight, I don't know what compromise or what talking to happened. But the producer said, I don't want to fight this case. So there went the case, there went the film, and the film never came out. But the point is, there is a great deal of advocacy and political messaging that art brings to us today. And we need to engage and hear those voices. Chaplin was driven out of Britain because he was seen as a communist supporter. He lived in the US and Switzerland till he died. And how often, I mean, Robert Redford, who passed recently, I was reading, had a political voice. He faced isolation from within his own Hollywood cohort. But the point is that human rights advocacy takes on many, many avatars. It takes on avatars through the art, of course, through the media, which, again, is two Indias in New India. There is the mainstream corporate media who perhaps does not even know how to spell the phrase human rights. And then there is the independent, autonomous social media trying to fight the good fight, but perpetually facing its own injunctions and its own persecution, as we all very well know, right from arrests under terror law to money laundering cases to injunctions of courts, as you recently saw, passed by the trial court, a blanket gag order in the Adani case. And I'm happy to see that the appellate court reversed it yesterday. Madam Vrinda Grover appeared and the order was reversed. It's a bold decision. But the gag orders, where the plaintiff themselves say, I will decide what is defamatory. So my own grand perception of my reputation will decide what is defamatory of me, and the court will injunct by way of gag orders. You saw it with the Dharmasthala instance. It took the High Court to reverse that injunction. And in the process, who faced the music? The journalists and the lawyers themselves. We now in Karnataka are speaking of the Advocates Protection Bill for protection of lawyers doing their duties on a daily basis. You take up a case, it's a lot easier when you're in the higher courts or in the Supreme Court. At a district level, you take up the case. I remember that Mohinder Singh Pander's case. There was a fatwa that no lawyer must touch this case. If anybody takes the case for the accused, they would be beaten. Fellow professionals. So these are the threats and the crises within which the system operates, and one must therefore stay engaged with these realities. I realize I have said a lot, but may I conclude, friends, by returning to the life of Reverend Dr. M.A. Thomas and what he's done. Clearly, his life was driven by the ideals of a better India. And this is where there is room for religion, formal or informal religion, to play a role of soothing and healing society. I believe there is no religion in the world that, in its essence, does not espouse compassion and goodness. Every religion does. Difficulty, of course, arises in matters of interpretation and application of religion. And with that comes power, property, ego, money, political interference, and what else, which then transmutes religion into what should have been a force for good as a force of not so good for people and society. But in its essence, I think religion in itself is an institutional form of human rights advocacy. Everything you heard in the introductory comments told you that human rights are very hard to define. The Magna Carta, Indian Constitution, Universal Declaration of Human Rights, etc. is all very well, but an innate spiritual, as Sir said, or an innate human and humane entitlement to all. And that's where I think religion becomes an important voice on an everyday basis to communicate, to convince people within its fold as to the importance of tolerance and humanity, right? Courts, media, art, they all have their own place. But perhaps, as was famously said, religion being the opiate of the masses, it is an opiate. The real effect or influence, and directly to if there's a voice that speaks to the heart, at least in India, it's often that of somebody within a position of power, within a religion. And therefore, I am proud and happy to have been part of this lecture because I can see ECC is doing it. The vision behind ECC, the role that Dr. Thomas envisaged was exactly this. And that is timeless. That doesn't belong to New India or Old India. It belongs to all Indias. And the Bible, I found in the book of Proverbs 31 verses 8 and 9 says, "Open your mouth for the speechless in the cause of all who are appointed to die. Open your mouth, judge righteously, and plead the cause of the poor and needy." I think I'll stop here. Thank you.
Dr. Aditya Sondhi spoke so powerfully on the struggles of minorities, on the plight of the marginalized, even the scavengers, giving voice to those who are often unheard. The depth and the sensitivity with which he addressed these issues truly reflected his commitment to human dignity and justice. On a lighter note, sitting behind you, I happened to notice your notes, complex, just like the traffic at Bangalore. It surprised me at first, but what struck me was the way you spoke with such clarity and depth, drawing from those complicated, complex notes so effortlessly. If you can handle a lecture so masterfully, I can just imagine how you can navigate and solve complex cases in the Supreme Court. Thank you once again, sir, for that lovely session. Now we open the floor for discussions. We have time for 3 questions at first.
Good morning, sir. I enjoyed your lecture. Yeah, thank you very much. So I came first time to hear for this lecture, and thank you for the director to invite me. And my question to you, sir. Sir, I fully agree with you. Human rights violations are happening in India. But you see, sir, the Indian growth after independence is tremendous. The youths are in a fully occupational area. All the youths are work. And also, we are going to the superpower in another few years. Now, my question to you is, only advocates or law is the key to this system change. As a common man, my question to you again, whether social media, churches, religion, these parts have a role in it. Okay, but part is that you recently I saw 2 nuns suffered. I'm not going to enlarge more. And one more, 2 or 3 years back, one Swami, I don't know the name, one Father Swami died also.
Stan Swami.
Yeah, exactly. So my question is, what was the law doing in that time? Kindly answer me, sir.
You know that Stan Swami's case, Father Stan Swami's case, he was not even granted bail. And I think that in some ways proves the point I was trying to make about the process being the punishment. And ultimately, when cases end in acquittals or conviction, people are forgotten or often they are gone. But the damage to their reputation and lives is done then. So you're right that without mentioning A case or B case, that the law has to be a lot more sensitive and expedient in dealing with them. Your earlier question, I think I did cover in terms of saying that advocacy of professionals and media, etc., has a limited role. The effect that perhaps religion can have is far greater, both for the good and not for the good. That consciousness is needed, and I think that's where interfaith, interdisciplinary conversations are required. I'm reminded of the hijab case which I had done in the Supreme Court, and though many saw that as just a Muslim Islamic issue, it opened up my eyes to the many layers of human rights involved in an issue as simple, if you will, as the hijab. And that was the right of a girl to go to school, many times a first learner, the right of access to education, right? And the right of expression. And many of these transcend religion. They have an interdisciplinary angle to them. And people need to therefore see and understand that. In fact, Sarasu, you'll be interested that while arguing, I used the example of National Law School. And I said I had Muslim girls in my class who just didn't wear the hijab. They thought it was a ritual that didn't belong to them because it was too theologically rigid. But the effect of the ban is on a very different strata. The effect is on the strata in a village or in an economic space where the parents will say to the girl, all right, we'll let you go to school on the condition that you wear the hijab. The moment you take the hijab off, you pull that child out of school. So religion has many, I think, socio-cultural, political layers to it and has an important role in this space. Yeah.
Thank you, sir, for the profound and excellent lecture. I take 2 imaginations from your lecture. That fascinates me most. Number one, the extension of the idea of rights, going beyond mere human rights, extending to the idea of animal rights, which can be further extended to ecological rights also. Wider perspective of rights. At the same time, second thing, definition of advocacy in terms of fostering communities of compassion. That is very meaningful and challenging. But I want to bring in another issue in our concern on human rights and advocacy. That is nothing else the idea of statism. Considering state and its tools or institutions like judiciary, military, as the final custodians of rights. So state determines rightings and wrongs. So is there any possibility for us people, especially from the perspective of the excluded and the marginalized, is there any possibility to reimagine even going beyond statism and thinking about communities of justice, where we find the meaning of relevance of religion, as you rightly pointed out at the end of your speech?
Yeah.
So how do you challenge statism and their institutions like judiciary, military, and they determines rightings and wrongings?
Yeah, that's a great question, sir. I think as long as these alternatives can be imagined, and they have been imagined, within at least the constitutional ethos and within a non-violent framework, I think there's ample room for it. If one takes this example to its extreme, the growth of Naxalism in India also was premised on this. What else was Naxalism? It was a countervailing force to overthrow the state through violent means, but with a view to achieve socio-economic justice. But the problem there is that it is hazardous to the unity and to the peace of the people. And those are alarming, extreme examples that I at least do not endorse, what Ambedkar himself called the grammar of anarchy. But short of that, in a non-violent and in a constitutional ethical framework, at least, if not a formal framework, of course there's role for it. And a lot of civil society, grassroots movement, Adivasi movements have grown in that lacuna. They have grown in that space. The only problem there is that many times it can become unguided. And that can then take you into religious dogma and the administration of justice through religious tenets. And one sees that happening. It happens in madrasas, it happens in khap panchayats. And that is, I think, disastrous to the overall ethos and the intent of the question you asked me. So if we can steer clear of that sort of policing, if you will, or that paradigm, in fact, there's great room for it. And a lot of that justice actually is achieved at a grassroots level. For an Adivasi who's affected by, say, the Forest Rights Act, people who have cohabited with animals for centuries, to be asked one fine morning to prove their entitlement to the land in which they live is near impossible. It's the same problem you're seeing with migration issues in Assam. I appear in that case. In the Sir, Bihar electoral cleansing, where one fine morning you're asked to prove your loyalty and your identity. It's not easy. If you and I are asked to put a file together in 24 hours, we'll be running helter-skelter, isn't it? And a lot of this justice delivery actually happens at that level, where activists and NGOs are able to liaise between the affected and the immediate systems, as I said. For the Adivasi or for the migrant, the Supreme Court is far away, sir. For them, the collector, the tehsildar, the magistrates court are the first and only point of contact. And you have good pro bono individuals, activists who bridge that gap. They put files together. They espouse the cause. That is really a non-statist justice delivery in some ways. I hope that answers your question. Here, I think there's a question in front.
Yeah. My name is Rajiv John and I represent the YMCA. Thank you very much, sir, for bringing this issue of the human rights. You've given a very broad perspective and you've covered almost every aspect. Now, you also mentioned the advocacy itself is a very risky proposition now. And we know the example of Father Stan Swami and many others. The advocates itself, who are advocating for the rights of the people, are put behind bars. Even Father Stan Swami was not even allowed a sipper to use it. So what do the social sector and how can we do? Like at times we feel helpless or maybe scared because of the mighty power of the government and the system. That how do we go ahead? Though we feel about it, but we feel suppressed or we don't know how to go ahead. So can you just elaborate on this?
That's
Thank you,
a
sir.
tough question, sir. I think in many ways, for me, it's a question of moral courage. If we can all show that extra moral courage within our own spaces, I think the good turn is done. Because a lot of people live in ivory towers and believe they are immune from this. It's not my problem. But as has often been said, at some point, these things catch up with you in one way or another. If nothing else, your karma catches up with you for those who believe in it. So I think showing moral courage, standing up for folks around you who might be affected with this, giving a voice to these issues. And in fact, it's a great time to do it because the mainstream media is not doing it. If the YMCA was to bring out a newsletter, as I believe you do, and pick up one cause a month and write about it, you're reaching out to someone and you're becoming a voice. And that courage is contagious. In fact, that is something I should have said, that New India has actually shown that for all of the odds that are against you, courage is contagious. And those who go solo and fight often find others following in their trail. So I would say it's that. I also think this is more of a personal response, that many times I find that the toxicity is very near us. The language that our own friends or classmates speak is alienating. Our political divide, I think, is no different from what the US is. Probably the difference is that in the US, somehow you're committed to one or the other, which is Democrat or Republican. In India, it doesn't mean if you're anti-majoritarian that by default you're Congress. There's a lot of gray nuance there. And there's an apolitical space, which is to say that you have strong political views, but that doesn't mean you have political affiliation of any sort. But that correction on a daily basis, to just speak to our own family or friends or neighbors who are out spewing toxic venom, many of them misinformed. And this is where I suppose faith comes in. You have to have that faith without losing hope that you might be able to change somebody's mind, certainly not everyone's, but you might change the minds or hearts of a few around you. And I suppose that is a good turn done. But otherwise, I can share your helplessness a little bit. Yeah, sure.
Jai Bhim, sir. Thank you for the insightful teaching. I framed my question, sir. In North Madras, youths, mostly Muslim, Dalits, and fishermen community, are often booked for petty cases, brutally handled by the police and remanded. This is not the same in other parts of the city. After imprisonment, these youths are pushed into becoming rowdies. They are made, not born. Within 2 years, many are either murdered or killed in encounters. Yet there is silence around this injustice. What can a human rights activist do in these situations?
Wow, that's a tough one. I mean, and it's ironical that you're speaking of a state that spearheaded the Dravidian movement, supposed to be one of the most egalitarian political movements in its essence. Well, from what you've said, the crux of the problem is on day one when these arbitrary arrests are made. As you said, for petty cases. It can be a petty case, you pinch somebody's cycle or something like that. But that's how the police playbook often works. You make the arrest, keep them in custody, may or may not produce before the magistrate, even though you're required to. And from there, the grain begins to change. They are often tortured or they are brainwashed. Or worse still, when we speak of under trials and custody, when people belonging to civil society are kept in the company of hardened criminals with a very different moral grain, that has its own influences. A lot of, I think, indoctrination can take place there. So from what you've asked me, I think the problem has to be nipped in the root, in the bud. It is at that stage one, if activists and lawyers can step in, move maybe habeas corpus petitions, keep the police on their toes. As you know, the Supreme Court has made an order for CCTVs in police stations. Again, difficult to implement, but at least it's there, right? To keep a watch on the watchdogs, to let them know that if you go out of line, some court somewhere is watching. I think the moment that happens, at least to some extent, the cause correction can take place. But beyond that, from what you're saying, it seems to be systemic. It should then, I'm afraid, it should then become a political agenda. The communities you're speaking of are the voting communities also. They are not powerless. Yeah, I think at the back there's a question. And then, yeah, we'll come back. We'll come to you in 1 second. Yeah.
Thank you, Dr. Aditya, for the lecture, and thank you, ECC, for the opportunity. When you were speaking about the advocacy, especially you made a point stating that art can be a very important medium in bringing about human rights advocacy. And nowadays, we have a very strong political voice coming in through mainstream media, filmmaking, especially to make it. And you also made it a point to say about the ban of Punjab 95. When we are looking at it from that lens, how effective has this type of an advocacy been in the society? Because there are some voices coming out which had not been there in previously, and now they are slowly coming out advocating for human rights and for equality through mainstream media. So are these voices taken up seriously when they are coming through mainstream media? Or have they been just seen as a source of entertainment alone when it comes through art?
No, in fact, I think many of these have low entertainment value. They're very real documentary films or spaces which show you things as they are. So no one takes them lightly. If anything, the entertainment is in the mainstream propaganda cinema, which is often laughable. You can't even call it art. But that's the art that finds its voice because it's supported. But take the entire issue with Gaza. Who is really speaking about it? It's artists, it's poets, it's filmmakers. And of course, people are taking them seriously. In fact, many of our engagement sitting this far away is through them. New York Times and The Guardian are not telling us about what's happening in Gaza. It is artists and grassroots poets and activists who are doing it. So I think there's tremendous room for it. There's also an aesthetic to it, which I think is very important. And this point comes to me from a podcast that I did with an artist called Siddesh Gautam. You must have, his pet name is Bakery Prasad. He does fantastic sketches. And he told me, he said, why is it that Baba Saheb must be projected in that same blue suit everywhere? It's reductionist. Art must also reflect the aesthetic of the cause. And you see his art, his Dalit art, his art on Ambedkar, it elevates it to art that should be bought and framed in rooms of people who may not even be engaged with the cause. You get what I'm saying? So there is that process of elevating it. So I think from both perspectives, art has a very important role to play. It actually ties in with the question that the gentleman asked, which is to say, somebody has to bridge this gap. Somebody has to show the mirror to society that what's happening to a certain sector around us is not that far removed from you. So, yeah. You had a question? Yes, the lady at the back.
Thank you so much for addressing a lot of different kinds of issues, right? One of the, I think, reasons that I took so long to formulate a question was because you touched upon so many varieties of conversations and threads of a lot of different years of your practice, right? Specifically with this particular topic, New India was something that caught my eye. The term New India, especially in a lot of new literature, like Oishik Sarkar's Violent Modernity is in New India, are marked by a lot of things that even you mentioned. It's marked by polarization, it's marked by the rise of the Hindu right, and it's marked by a lot of different kinds of neoliberalist and neo-capitalist ideas. But additionally, we also have this rise of what a lot of people describe as a transformative constitutionalism, some of which that you've contributed to through your work. how does that necessarily work in terms of translating to state implementation? I work very closely with the government, and a lot of ways that the government looks at policy problems and a lot of social justice issues is through very technocratic lenses. So, how does your work and a transformative constitution translate into statesmanship?
Yeah, not easily, if I can answer that in 2 words. But what it does is it creates, I think, a certain consciousness. And that, for me, is the most important thing. The bridge between, high-sounding, please sit down, the high-sounding constitutional principles and their everyday implementation is sometimes a bridge too far. You take the example of the unauthorized demolitions case itself. I thought that was a far-reaching order from the Supreme Court, because this took policing to a new level of moral policing, which was to say the moment somebody is accused of a crime, their family property must be bulldozed the next morning. I mean, that is anarchy, if you ask me, and it was happening. And despite the order and the many, many safeguards in the order, it was not just transformative in terms of the principles it laid down. I think it was also very pragmatic, because it laid down in black and white the exact technocratic or bureaucratic steps that come into play, which is to say, when you give somebody a notice of demolition, you give them reasonable time to turn around. If you say 24-hour notice and you're asked to show property papers, etc., most people will not be able to meet that requirement. And here you have a notice on paper pasted somewhere. The next morning, there's a demolition. But despite all of this, demolitions continued, and they continue to the day. And there is a certain sort of bullheadedness of the bureaucracy, if you will, or the police and the state machinery, if you will, which seems to think that these orders are not for us, or somebody will protect us somewhere. I think that needs to change. I think courts now have to walk that last mile. Last mile connectivity is Bangalore's favorite phrase. That last mile has to be walked. And unless the courts can themselves monitor the actual execution of these orders, I'm afraid a lot of this just remains in the air. But there is a consciousness that's created. I think that's very important when it comes to equality, to queer rights, ecology, etc. We know that these orders are far removed from their intent and their execution on the ground. But they do, I think, certainly lay down the framework. But there is your question has many layers to it. There is one fundamental problem that I see as a practitioner, because I think a lot that I'm saying is philosophical. The practical problem that I see is that there are many systems in our country, political systems, bureaucratic systems, that do not seem to take the courts seriously enough. And for me, that is a huge problem, because our entire doctrine of rule of law is based on faith in the courts. It's a faith that fortunately a lot of people still have, despite all the cynicism, etc. But that faith or that regard, I don't see enough from within the systems. And which is why courts, again, you must have seen, are flooded with contempt petitions. Contempt law has got a bad name because it's used sometimes, not all the time, sometimes to deal with, the Arundhati Roys of the world who say something too caustic about a judge or a court. But that is what you call criminal contempt. The bread and butter civil contempt is for disobedience of orders of courts. And high courts and the Supreme Court are flooded with contempt petitions because every order that is passed fails to be implemented. And we have to, I think, address that. It's a great area for anybody in the scholarship of the law to see why does that happen. And for that law is transformative at every level. For that individual, that widow who's got an order for pension of her husband, to get that paltry 25,000 a month means not just the order of the court, but a follow-up writ appeal and a Supreme Court proceeding, and then a contempt petition that will lie in court till such time some officer somewhere is, threatened with prison, hauled up for contempt and said, for God's sake, sign the order, sign the check. And for me as a practitioner, that's the nub. What's the reason? Is it inbuilt? Is it a tradition? Is it that government lawyers don't communicate this seriously enough to their clients? Is it all of the above? Could be. But if we're able to bridge this and build a greater sort of sensitivity and reaction and an efficiency, for the want of a better word, within the bureaucracy, I think that's when transformative constitutional can really work. Yeah, done. Thank you.